whichever way we look at it, whether we're dealing with a lender or a lender solicitor or whoever may be acting, we have a very good professional relationship whereby we can have a conversation, we can put things in writing, whatever we need to do to get things agreed. But ultimately, I can't force them to agree it, and I can't force the guarantor to agree it. I've got to create the environment whereby both can say, you know what, we can do that. And that's the ultimate secret. We're not bothered about proving who's right or who's wrong. All we're trying to do is to create that environment whereby both parties can say, that's something we can do.
If you've signed a personal guarantee as a director in the UK today, it might be a good idea to watch the rest of this interview, because today I'm going to be interviewing Gary Whitehead of AFT Assist. I've worked with Gary for many, many years, and when it comes to personal guarantees and helping directors, for me, he's the number one in the country. Gary, welcome to the Director First podcast, mate. I know we've done one in the past, but this is the first one we've done in the flesh. Thanks for coming over.
Great to be here, and thanks for inviting me, Chris.
Anytime, mate. Listen, Gary, before we get into this, can you sort of give us the backstory of, you know, how you ended up working in this industry and becoming the specialist at what you do?
Yeah, by all means. I mean, for my sins, I spent best part of 20 years working at Barclays. Left school and joined Barclays in the early 80s. It was old school banking at the time, where you tended to do everything, not quite Captain Mannering, but that sort of thing. You did everything in-house, so they taught you very well. Left there in 2001 and set up a lending business myself, which did very well until the financial crisis of 2008, 2009, when I was very much on the receiving end, just like the people that we're helping now. And it was as I was going through that process, I realised how difficult it was for even for somebody that knew what they were doing. So how it would be for people who don't know what they're doing, well, perish the thought at the time. So as I was going through that process, I got, when I started talking to people and telling them what I was going through, I got approached by a couple of friends who had friends of friends, if you like, that were experiencing their own difficulties with lenders, and asking if I could help them out. So I just helped a few people out as a favour, really, not as a business, just doing it for free. And we sorted them out, and I seemed to be quite good at it. So after thinking about 2014, I thought it'd be a good idea to see if we could actually launch this as a business where we could help people that are going through a difficult time, probably when they need it the most, and see how we could use that as a business going forward.
Wow.
And so that's how we set up AFT back in, well, over nearly 11 years ago now.
That's amazing. I mean, I can completely identify. Obviously, I got into insolvency in a strange way. It wasn't a career choice for me. I had to go for a liquidation and come out of the back of that, and teamed up with somebody who said, listen, we could get some work for these insolvency practitioners. And I find that gives me a real unique viewpoint when I'm dealing with clients, because I've genuinely been there, you know, and I sort of know what they're going through, and that must put you in quite a good position to assist these people.
Absolutely. It's like you've been there, got the t-shirt, so to speak. And I never shy away telling people about the fact that I went through the difficulties, because it allows them to, you know, when people say, I understand what you're going through, most of the time they don't. But if you explain what you went through, all of a sudden they do realise that you do understand what they're going through, and that you can give them some hope that there is a future beyond where they are now. Our job is about giving people some light at the end of the tunnel, so to speak, and if they've got that light, they're prepared to fight to get through it. It's not going to be difficult, it's not going to be easy, because if it was easy, the lenders that we work with that wouldn't actually agree it. But people are prepared to fight if they can see that light. It's when they can't see the light that's the problem, and then the world starts closing in around people, and they get the issues certainly with mental health and all that sort of stuff. And so anything we can do to help them get through the process and give them that way forward, that's what we're all about.
Could you tell us a little bit more what it was like for you, sort of what happened and how you got through it?
It was difficult. It was very difficult. You know, at the time when you've got nobody to turn to for help, you do undoubtedly start getting issues with mental health. And if I look back, I can probably say that at some stage during that process I was clinically depressed. But I was fortunate in that something just clicked in my mind and said, almost like, I'm not going to let this beat me. I'm going to get through it, and I'm going to come back, and I'm going to come back stronger. And I was, trying to think how old I was, I'd been mid-40s. Mm-hmm. So I was young enough, if you like, to be able to build again, because that's what it's all about. It's about saying, well, okay, we've gone through these difficulties. We need to put it to one side, deal with the consequences, but also look to the future. Because again, it's about what we said before, giving people that light at the end of the tunnel so they can see that there's a future that's worth fighting for.
That shows incredible resilience.
Undoubtedly, you've got to have resilience, because when you're looking at something, you know, like this, it is easier to give up.
Yeah.
But giving up's not the answer.
And there must have been times where you thought, you know, it's just not worth this. I can't, you know, was there ever times where I'm just going to go and get a job? I'm just going to...
There was times like that, but you've got to think of your family. I always say to people, money's irrelevant when it comes to health and family. They are by far the most important things. And if you're ever getting to a stage whereby your health and family are becoming the problem, you should give in on the money side and just make sure you concentrate on looking after your health and looking after your family. You don't want to be the richest man in the graveyard, so to speak. But we do get occasionally people that say, look, I can't take it anymore. And you've got to then take a totally different strategy in terms of dealing with it, because fundamentally you've got to look after the person on the other side of the phone, or our clients, if you like, to make sure that we're getting the best solution that we can for them.
How do you handle something like that when somebody, you know, comes out with, listen, I've had enough, I want to end it all?
Very difficult. It's a very difficult. I've only had it in one situation where we were already starting the process, and somebody did ring me up and said, I was in Liverpool at the time, and they said, you know, Gary, I'm going to give it till Friday, and then I'm going to call it a day. And I felt, I don't understand that. You can't call it a day. The lenders are coming after you. You can't just call it a day. And he said, oh no, I'm going to kill myself. And I thought, gosh, well, you know, what am I going to do now? So I literally, luckily at the time, he was fairly close. So I went round, saw the guy. You could see at the time that his mental health he was really struggling. Luckily his family was all there, because I was thinking, has he just told me? Has he not told anybody else? But his family was all there, and they managed to rally round him, support him. But we had to change tack, and it wasn't about trying to get the best deal. It was about just getting it done quickly to protect him, and we did. Ultimately the family managed to borrow money to pay off the debt, and I can still remember it to this day, the day the debt was paid off, which was literally 2 weeks later. He rang me up and said, Gary, it's all done. We're having a barbecue at the weekend. Bring the family.
Wow.
And so we've got a situation there where somebody's gone from the real depths of despair to all of a sudden we're having a party and we're looking forward to the future.
Yeah.
And that's what it's all about.
Yeah,
it's not about anything other than, everything else is a bonus. That's what it's all about.
Yeah, that's an incredible story. What are the sort of most common mistakes that directors are making with personal guarantees?
The most common one is not knowing they've signed them, because they don't read the documents. A lot of people, especially when they're just starting in business or they've not been in business very long, don't realise the implications of being in business. And what I mean by that is, if you go to Curry's and borrow money to buy a telly, you're very well protected with the FCA and CCA and all the other regulations. But when you're in business, especially if you're a director, you've got no protection at all. So if you didn't read it, it's your fault. If you didn't understand it, it's your fault. There's no obligation on lenders to make sure that you did both of those sort of things. And that's the biggest mistake that people realise, don't actually read the documents and understand what they're actually doing. And guarantees don't have to be 15 pages. They can be 4 or 5 lines in a document, as long as it says personal guarantee or hereby guarantee the company's obligations, then that could be just equally as valid as a 15-page document. So you've just got to be very careful. So that's probably the biggest mistake that we see, directors not realising what they've signed.
And people are under this false illusion that they have to get legal advice. I mean, I know when I needed some commercial finance for a property deal, the lender, I had to get independent legal advice on that money. Is that not the norm?
No, the norm is they would normally put some sort of warning on the document suggesting that you get legal advice, but there's no obligation on a lender to ensure that you do. They rely on what we said before. Directors are supposed to know what they're doing, and so it's up to them to decide what they want to do. And it's a bit of a misconception that people think because they didn't get legal advice somehow that the guarantee is now not valid, when that's not the case. And the problem you've got now is that lenders, especially the non-high street lenders, are all about providing finance quickly. And if you started to insist on people taking legal advice, it's going to extend the process by weeks, and you've got another lender around the corner that will do it very quickly without that. And so that competition drives the fact that lenders, the vast majority of lenders, do not insist on legal advice anymore.
But from a director's point of view, surely they should be taking legal advice before they sign anything.
They should be. But the key factor is not the legal advice, as opposed to making sure you understand what it is you're signing. Whether you need legal advice or you can do that yourself is up to the individual director. But it's understanding what you're actually signing up to. That's the fundamental issue here, and that's what most directors probably don't realise what they're doing.
I had a case before Christmas, and it was a director who's looking to go through some type of insolvency process, and there was a factoring company that had a charge. So we had to look at the details of this debenture and the guarantee. And it was something called an evergreen contract, which actually has been, I don't know if it's been outlawed, but you're really not meant to use them anymore. And he thought he'd taken a 3-month agreement from this facility. But when you dug into it, he had to give 12 months notice. And after the 12 months, he could only cancel on one specific day. And we've had that conversation, and I've called him John for argument's sake. I said, John, why did you sign this? Why have you not taken any? And he just said, Chris, I was desperate. I needed the money. And that's because people are vulnerable, aren't they? And we're dealing with vulnerable people day in and day out. So what type of advice could you give to somebody out there who is considering getting a personal guarantee? Well, giving a personal guarantee.
I think it goes back to making sure that you don't do anything quickly. And when I say quickly, it might take an hour to read the documents and understand them. The problem you've got a lot of the time is, you know, the lenders are there saying, just sign this now and you'll have the money in 20 minutes. And that outweighs, for a lot of people, the thought of actually going through the documents. That money will still be there in 2 hours. But because it's there and it's there now, people just don't read the documents, or they misunderstand that they believe the lenders are obliged to make sure that they point out what the risks are and about the guarantee, when that's not the case. So first and foremost, take your time, make sure you read the documents. You've got to be careful when you, for instance, people borrow money to pay wages at the week. The wages are due on Friday, and I've got to pay the wages, and I can borrow the money. And then the next week they've got more wages and they borrow more money again. And each time they're given a personal guarantee. Well, that in itself, to me, is not a problem, providing you understand them and you've got a plan to take this business forward. The problem you tend to get is a lot of people do it as a knee-jerk reaction without having the plan. I'm just solving my problem today, but I haven't got a plan for next week or the week after. And whereas they're doing it perhaps for the right reasons to pay the wages, what they're actually doing is digging their own hole deeper.
Putting a plaster over it.
Yeah, not only putting the plastering over the business, because they're going to have the same problem next week, but they're putting their own personal assets at risk every time they borrow this money without any sort of plan as to how they're going to get the business to go forward and get themselves out of it. It's just a knee-jerk reaction to cover the problem we've got today because they don't want to grasp the nettle about the future.
I mean, we hear it about good debt and bad debt. You know, could you sort of give us your take on what you think good debt is for a business, what you think bad debt is for the business, what the differences are, what you should be looking out for?
I mean, the way that there's nothing wrong with borrowing money. There's nothing wrong with giving a personal guarantee, as long as you understand the risks that you're taking when you do it. And what I mean by that, it's not just the fact that you've given the personal guarantee. It's the fact that you need to understand that residential houses, your own house is not protected, even if it's in joint names, even if you've got young kids. It doesn't mean your house is protected. It's not. So there's understanding the implications of what a personal guarantee is, but there's also understanding the business. Do I understand what the plan is for this business? Where am I going with this business? If I borrow this money, does it have a chance of resolving the problem that I've got today? Because if there's no resolution, you're just going to have the same problem tomorrow or the day after. You're just knocking the can down the road. So good debt to me is linked to understanding the risks of what you're doing from personally and understanding the business in terms of, will this solve the business problem, or is the problem just too big already and this is just putting a plaster on a gaping wound?
And the only way really to understand whether it's going to solve that problem in the business is to have some really accurate information to make these decisions on.
Correct.
I mean, one of the main problems that we see with directors of businesses of all sizes is not having their finger on the pulse when it comes to that monthly profit and loss, that 13-week rolling cash flow. You know, so they're making decisions based on what's in the money in the bank. And it all boils down to that, doesn't it? It's like, listen, you can only run a business regardless of your size if you are getting timely numbers on a monthly basis. And if you've got that information, and that, I discussed it with someone today, like a business can be insolvent, a seasonal business, there are times in the year that it might become insolvent, but they're waiting on a job to come off, they're waiting to get paid off. And if that money's secure, if that contract's signed, it's just a case of getting on site. Well, the idea of signing a personal guarantee to get me through that short term, it's not such a bad idea, is it?
No, not at all. That's sensible borrowing. That's the good money that you mentioned before.
Give us an example where it's a bad idea.
Well, the bad idea would be, you know, I've got no financial information. I've got no idea what the business is, but I've got a bill to pay. And so I'm going to borrow money to pay that bill. And without the information, I've got no idea whether, having borrowed that money to pay that bill, the problem that the business has got is resolved or not. Or what we need to do after that to resolve the problem. And so it goes back to what we were saying before, we're putting that sticking plaster over the problem that's today without knowing what the position is tomorrow. And a lot of people, I'm putting my old bank manager's hat on now, a lot of people only do forecasts for the bank or something like that. Well, forecasts are not for anybody else, they're for the directors. So the directors can understand where the business is and where's it going and the risks and what the business needs to do to avoid the problems, rather than, you know, it's like, you know, if you see there's an iceberg coming, if you know early enough, you can steer around it.
Yeah.
But if you don't, you just plough straight into the iceberg and then your business is in deep trouble.
I mean, I'm not going to name specific lenders, but it just seems to me really easy to... The banks are harder to deal with, the high street banks, but there are specific lenders that I will see day in, day out in insolvency that seem to lend to anybody. I mean, What are your thoughts on those? Because you're dealing with it. We know who we're talking about here.
Yeah, the financial crisis of 2008, 2009, there was then an explosion of lenders coming into the market because banks just didn't want to lend, and they were filling the gap. And that's fine, but these lenders are not banks. They cannot do the due diligence that banks do and do it quickly. So there's got to be corners that's got to be cut. And what worries me with lenders that I see a lot is they don't look at the proposition in too much detail. They look at the guarantor and the equity that the guarantor's got in his house. Because they think that it doesn't matter if it goes wrong, as long as there's equity.
Do they? Potentially, And
I wouldn't say they don't care, because that's probably a bit unfair. But the reality is the biggest thing that they're looking for may well be just how much equity the client's got, the directors have got in their house. And you get situations whereby you've got perhaps a director that's, houses in wife's name, for instance. And we see this regularly. They say, well, we can't lend you the money because the house is in wife's name, unless your wife becomes a director, and then she can sign the guarantee, and then that ties in the equity that's in the house, even though the wife may have absolutely no knowledge of the business. But because she then becomes a director, she's not got the protection that she had before, and so we've got the same issues that we've talked about earlier on in the interview. So it's one of those situations, again, whereby the explosion of lenders is a good thing because it provides businesses with access to finance. And we can't get away from that. It's a good thing. But you've got to, as a director, realise how these lenders work. If you could just ring up and get the money there and then, within an hour, they're not going to do a lot of checks.
But your bollocks are on the line if it goes wrong.
But absolutely, and that's the fundamental concern. But that's the way we live. And I don't know, overall, it's a good thing, all these lenders, if all directors understood. But unfortunately, most directors don't, and so they leave themselves open.
What are some of the biggest misconceptions when it comes to personal guarantees?
The biggest one is what I mentioned before, Chris, where people think that even though the house is in joint names, but it's protected because it's in joint names or because I've got young kids or whatever. And unfortunately, that's not the case. Or if you give a guarantee, all of your assets, no matter whose name, if they're in with other people, are at risk. And unfortunately, that's probably the biggest mistake, if you like, people make when they're considering these situations.
When a personal guarantee is getting called in, so obviously let's say, run us through the process. What actually happens? How does it all unfold?
Okay, so the first thing that's got to happen is that the facility, whatever the facility is, has got to go into default. Now, with a loan, for instance, not making the payment is a term of default. But equally, if the company goes into insolvency, even though it hasn't missed a payment, then that would also be a term of
personally guaranteed debt in the company's name originally, but the director has backed it up with a PG. Company goes through a liquidation, administration,
or misses payments, or if there's other terms of conditions of the loan that they are in breach of, that would be a term of default. And so what would then happen is the lender would make demand on the company for repayment of all of its money back, and generally at the same time make the same demand on the guarantor, which basically says the company hasn't made its payments or it's in default because of this. We hereby demand 100,000, whatever it is, back within the next 7 days. And that's the start of the process against the guarantor. If nothing happens after that process, the lender's then got a number of options in terms of how it goes about recovering money. The key thing I would say to anybody in that situation, even if you don't want professional help, you can't bury your head in the sand. You've got to deal with the situation, because burying your head in the sand is the worst thing anybody can do, because lenders will just assume that you're not responding, and it forces their hand to do something more in terms of the recovery process. And that recovery process is generally one of two things. Either they could issue what they call a statutory demand, and that is the start of bankruptcy proceedings against the director. Or they could issue the traditional debt claim, which is the CCJ route, and then take them to court, obtain a county court judgment, and then that opens them up to getting perhaps a charging order on somebody's house. And there's very little the director can do to prevent that happening.
Could you tell us a bit more about this charging order and how when does that normally happen? Is it typical? What can someone? Is there anything that we can do about it?
The biggest thing they can do is try and sort it out before it gets to that stage, because from most lenders' perspective, the charging order is one of the last options that they've got to make sure that they can hopefully get their money back. Some lenders do it as a matter of course because they want to put pressure on the guarantor to get in touch and sort things out. But the charging order process is they've got to get a CCJ, so they've got to get the county court judgment, which will obviously go on the credit file, personal credit file, and as soon as they've got that, they can apply for a charging order, and the first thing the guarantor will know is that they'll get something through the post saying that what they call an interim charging order has been granted.
So there's no warning. There's no
warning.
There's no like, no, you can't do that.
Well, you've then got the chance to put an objection
Okay.
into court, or people have got the chance of putting an objection into court. Been out of my area because I'm not a lawyer, but there's not a lot you can really say to challenge because the debt has been proven. They've got a county court judgment, and you've got an asset that they're entitled to take a charge on.
And then what happens?
Well, then you've got if you've not engaged, you've got the worst of all worlds, because you've got a CCJ and a charge on your house, and you've got no agreements in place whereby you can repay the debt. So it's then up to the lender to decide what it wants to do. Does it want to just sit back and in effect let interest carry on accruing and wait till you do something with your house, in which case they'll get their money back, all costs and interest? Or they could actually take it further and try and apply to the court for an order for sale. So it is quite a serious situation that if you can, needs to be avoided.
If you go down the stat demand route, what happens then?
The statutory demand, as we said before, is the start of bankruptcy proceedings. And a statutory demand says, basically, we believe that you owe us this amount of money in relation to the personal guarantee. You've got 21 days to pay it or 18 days to dispute it. If you do neither, at the end of the 21 days, the lender can actually apply to make you bankrupt. Takes a little bit of time, but they'll go to court, and then if you are made bankrupt, in effect, all of your assets are no longer yours. They belong to the trustee in bankruptcy, whose job it is to sell those assets, if you like, to pay off as much of your creditors as they can, and that includes your house. Now, I would say on this front, there's nothing they can do against your house quickly. It's not like they can come and knock on the door and say you're out, but over time, they will force the sale of your house, or alternatively, your wife or partner might be able to buy your equity out, but something has to be done in relation to the property. The status quo is not an option.
So what does that process look like? Someone's made bankrupt, then what? So they made bankrupt in the January. What happens?
They'll get notified of it initially from the official receiver, assuming that the lender doesn't want to put their own trustee in bankruptcy in to investigate matters. They'll have to complete a form, probably go for an interview, and their affairs may be investigated by the person looking after their affairs. But ultimately, if they have got a house, I think there's probably nothing that a lender can do, or the trustee in bankruptcy can do for a period of 12 months. But during that 12 months, the bankrupt and the partner have to look at what are they going to do with their property. Because ultimately, it's the equity that belongs to the partner that's made bankrupt does have to be realised, sold, and the only real options are for the partner to try and buy that equity out, or for the property to be sold. And even if the partner says, I don't want to sell, again, they can go to court and ultimately force the sale. But nothing quickly, probably take between 12 and 24 months. But it's there and it's going to happen at some stage unless something else can be done to strike a deal, so to speak, to buy that equity out.
Tell me about that, you know, actually buying the equity. What does that look like? Or any deals can be done? How is the equity determined? Are there any discounts that can be offered? Are there payment terms? What does that look like?
Well, I think it's like with anything. There are options where a deal could be done, so to speak, because it might be easier for the trustee to strike a deal now rather than go through all the costs and legals of trying to force the issue and throw the family out of the house ultimately, etc., etc. But people have to be realistic as to what that deal might look like. So the house would be valued, probably by a couple of people. Perhaps the trustee in bankruptcy would get their valuation. The partner of the person that's gone bankrupt might get their own, and a figure would be agreed as to the realistic value of that house. They would work out the equity based on the mortgage. Half that equity would then be the belonging to the person that's gone bankrupt, and there would then be some conversation about how much of that would it cost for the partner to buy that value of equity out. There's no hard and fast rules. Every case is going to be looked at differently, and there is the earlier you can strike a deal, normally the better deal that you can obtain. But you're not going to get it for nothing. It's not going to be. You've got to be realistic as to what can be achieved.
And are you going to have to pay it up front, or are there going to be some term? I don't know. Say there's 50 grand equity that's agreed. Will they give you 5 years to pay it?
It's probably unlikely that they're going to give you 5 years to pay it. And what, you know, it's like with anything, whether it's something like this, whether it's in relation to personal guarantees, the longer you want to pay, the less opportunity you have of getting anything off the debt. So if you're looking at a situation whereby you're buying half the house, the longer it takes and the longer you want to pay it, the more you'll end up paying.
How hostile and aggressive are lenders? Is this the norm? Is this part of their playbook?
All lenders are different, and there are lenders that are very willing to delay matters, but there are lenders that literally will go straight down the statutory demand route and the bankruptcy route as soon as you miss a payment, and they use that as a means of putting the person under pressure because it allows them to get to the front of the queue, and they'll hopefully get priority in terms of any discussions about how they're going to get paid back. So it is, and in fairness, it's a legitimate tactic, but people use it a lot quicker and a lot more aggressively than others.
So I want to get as much value in this call, and I know the last podcast, you know, people have picked up the phone to you on the back of
absolutely.
that.
Yeah, absolutely.
But if someone's watching this and going, you know, what would you say to somebody if I don't want them to be doing this themselves, right? Let me make that clear, right? Because too much is on the line. But if somebody was faced with this problem and they wanted to do something about it themselves, where would they start?
First thing they've got to do is engage with the lender.
Or the
lenders, depending on how many we're talking about. But the problem you've got, it's almost like if you don't know the rules of the game, how can you play the game? And that's the issue. And that's the issue we've got. So we'd always say to people, you know, and the analogy I always give is, I've never done any bricklaying in my life, and I could have a go, but I wouldn't start building a house because the penalties of getting it wrong far outweigh the costs of somebody doing it right. And it's the same sort of situation. But we also have to recognise that what seeking professional help does come with a cost, and some people are not in a position to be able to do that. And so they still have to engage, but to some extent they are then trusting that the lenders will do the right thing. And in most cases, the lenders are really looking after themselves. They're not really looking after the client. But you've got to engage, and you've got to keep your wits about you. But ultimately, you are going to rely on the lenders doing the right thing by you.
So my message is, dear God, you don't do, this is not something to do DIY, okay?
I would agree with you, with the proviso that everybody's got to understand that if you haven't got the ability to seek help, doing nothing is the worst option. So there's a level of different, from getting the professional help, trying to deal with yourself, and the absolute worst of the worst option is burying your head in the sand and doing nothing.
When I speak to directors and they may owe the bank 20 grand, that's a very different scenario to some of the case. Because I've passed people on to you for years. I've been so happy with what you've done. And I love the fact that you give people a lot of time. You're not on the phone going, right, I want X thousand now to talk to you. And I've always, at that type of level, somebody should be able to do it themselves, would you say?
At what sort of level?
20 grand.
Oh, right. Well, I mean, there is a difference between dealing with a bank and dealing with a lot of different smaller lenders.
Can you explain that difference to us?
The bank, even though we've got to accept that all the lending that's in relation to business, where there's a personal guarantee, is non-regulated. So the lenders are not bound by the rules that they would be if this was a personal loan, like a Barclay card or something like that. But when you're dealing with banks who are heavily regulated themselves, whereas they are non-regulated debt, banks do look at them with an element of regulated eyes, whereas other people might not do that. Now, that's not to say that you shouldn't get professional help because you can trust the banks, because they're still going to be looking at doing what they want rather than what the client wants. But there's an element of, if you've got two choices, dealing with a bank is probably the best option than dealing with, I'm not going to mention any names, but one of the smaller non-regulated lenders.
Okay, so let me run a scenario. There is a director that has a 25 grand overdraft personally guaranteed with a high street bank. He's gone through insolvency, doesn't really have any money for professional advice. What would you be saying to that director? If he's watching this podcast now, what's his process for getting that 25 grand overdraft dealt with?
The bank will be, or the lender will be in contact with him at some stage. Banks are generally quite slow compared to others, but they will at some stage be in contact. You've got to engage, but you've also got to be realistic from your own perspective. And what I mean by that is, if somebody comes and says, right, we want £25,000 tomorrow, or you can pay it back at £1,000 a month. Most people say, I'll take the £1,000 a month. But if you can't afford £1,000 a month, all you're doing is creating a bigger problem for next month or the month after, when you can't afford to meet the payments. So everybody's got to be realistic. It's not what the lender wants, it's what the guarantor can deliver. That's the important factor. And most people don't look at it like that. They ask me, well, what would the lender want? I said, well, that's not the question. The question is, what can you afford? And what you can afford is what we've then got to try and sort it out with.
Because at that level, I mean, how much is it a problem with a bank? At that level, 25 grand. Does the bank really want to be taking legal action against a director? How far are they going to push it?
Well, if you don't engage with them, they've got no choice, because ultimately that's their only way they're going to get the money back. Banks also, they do engage with debt recovery agents to try and take a bit of pressure off them. I suppose the question is more about how long would they give you to pay this debt back, assuming you're not in a position
to
pay it. Now,
how far can you push it as a director? How far can you negotiate out?
It all depends on the financial circumstances of the person, you know, because every case you've got to look at it on its own merits, and those merits are not only is there any issues with the documentation, or is there any shortcomings that we might be able to highlight.
But it's highly unlikely that a director is going to see those shortcomings.
No, it's very unlikely. But also then you've got to look at the financial position. Somebody who's sat in £1 million house with no mortgage is a totally different prospect to somebody who's in rented accommodation and has got no other assets. Mm-hmm. And so all the solution that can be obtained is all related to the alternative the lenders have got to do it themselves. And so if the lender's got an easy route to get all the money back this way, they're not going to accept a more challenging route over here. So it's all those things have got to be in the mix. But, you know, realistically, in most cases, 5 years, 10 years perhaps, may be possible, even longer in certain circumstances.
And can you stop the interest?
We always try and stop the interest, but we've got to recognise there's no obligation on lenders to stop interest. They're entitled, like anybody is, even in business, you're entitled to charge interest for any overdue invoices until that invoice is paid. And it's the same with lenders. They're entitled to charge interest until their debt is repaid. I think one of the things you've got to also look at is the terms of the facility, especially with some of the smaller lenders. The interest and the charges they can charge when things go wrong can be quite significant and massively different to what they would be charging if things were going right.
Let's compare that then. So that's the high street. Let's compare that to another lender that you owe 20, 25 grand to. You've signed a personal guarantee, and we know who those lenders are. They'll be emailing you, phone calling. There'll be things on your doorstep at home saying, every week I get something saying I can have a card with up to whatever. So let's run that scenario through. And again, someone wants to do it themselves here. Again, we're not advising them to do it. Yeah. But what would you suggest that they do if one of those lenders, they're not the high street, they've got a bit of a different view, haven't they? Smaller lenders have a different view, because £25,000 to a small lender is a hell of more of an impact than £25,000 to Barclays Bank. Mm-hmm. So it's got a bigger impact on lenders. And they do have a different view, and a lot of the time they can be quite aggressive to try and get that money back. The principle of engaging remains the same, but when you're dealing with lenders, you have to understand the issues that the lender might have and what the lender's requirements might be if you're trying to put together a proposal that they can accept. And that becomes very difficult when you're doing it on your own, because you've not got the experience and knowledge. And again, it goes back to all you can do is engage with the lender and hope that the lenders do the right thing by you. But it's more of a risk. It's more of a risk in those circumstances than it would be if it was Barclays Bank or one of the other high street banks. Outline some of the problems with those. I say a smaller loan. I just understand what level of loans that you've dealt with. That's that 25 grand example. You go into a lender that's not the high street. Yeah. What are some of the severe consequences that could happen if they don't get this done correctly? They're engaging, okay, they are engaging, but what are the things that could go wrong if they do it themselves? Well, the most serious is that the lender goes down the bankruptcy route and makes them bankrupt. Is that likely at 25 grand? They only need to prove a debt of £5,000 to go down the bankruptcy route. Okay. So £25,000 is a significant sum greater than that. And there are lenders that use bankruptcy as a means of making sure that they get to the top of the table. And there are lenders that will actually say, yeah, no, we're not bothered, we'll make somebody bankrupt for £25,000. There are lenders that will do that. Even those lenders, you would hope that if it was done properly, there would be a chance of them avoiding that. But we can't say that it's not a risk, because it is a risk. And most business borrowing is going to be over £5,000. Mm-hmm. There are lenders that
that don't do that.
Well, that's Armageddon, isn't it?
That's
Let's bring
Armageddon.
it back down. You know, what's the notch down? They're not going to make you bankrupt over 25 grand. What else might they do that's going to really cause you problems?
The other option is then looking at CCJs. Okay. If you don't engage with them, if they've got no choice, they can go down the court route, they get a CCJ against you. Obviously, that then goes on your credit file and causes you problems going forward. But then it opens up a whole wide range of different things they can do in relation to enforcing that. We've already talked about charging orders. Mm-hmm. That's one option that lenders can do. There are other options which I'm not a solicitor, so I don't know them all in terms of those debt recovery, but they can get attachment of earnings. They can do all sorts of different things to enforce that county court judgments once they've got it. So that's the sort of next tier down. And
that's for, and again, I'm not making light of a situation. 25 grand's a lot of money if you haven't got it, but I would say that's the lower end of the scale that certainly we have to deal with. My advice is you don't do this on your own. Exactly like yourself. I mean, I could have a go at doing my own tax returning, but I get my accountant to do it because he gets a different outcome. What's the difference with working with you? What do you different? What do you bring to the table? Let's run those scenarios again.
Okay, well, it's probably easy to explain what we would do in relation to a particular case. So the first thing we would do is contact the lender, ask for copies of various documents and understanding what the debt is. We will then talk through with the director, the guarantor, and talk a little bit about background of the business and what went wrong. We'll talk about the lending. Is there anything in the lending that's not? It's very unlikely that the lender's done something totally catastrophic, which means there's no liability at all. But if there's anything there that we can use to our advantage to help us support a business case, we'll try and bring that out.
Can I dive into that?
Go on.
What are you looking for? I mean, give us some examples where something has gone wrong, which has limited the liability or perhaps even got rid of it in
Well, I'll
its
give you an
entirety.
example. I'll give you an example of a situation whereby people might think there's no chance the lenders can do anything there. And it goes back to what I said before. It's very unlikely they're going to do something so wrong that they're going to get off it. And we've had situations whereby lenders have not done the guarantee correctly. And so instead of, I, Chris Worden, hereby guarantee ABC Limited, the guarantee could say, I, Chris Worden, hereby guarantee Chris Worden.
Wow.
No mention of the company at all.
Okay.
Now, people might think, you know what, in those sort of circumstances, there's no way this guarantee is enforceable. I'm off the hook. Unfortunately, it's not quite as simple as that, because the lenders or the lenders' solicitors can start to look at ways of saying, well, clearly that was a mistake. And the intention was always to provide a guarantee to the company. Mm-hmm. And so they could then seek to try and get a court to look through the mistake and still enforce the guarantee against the company's debt. So it's not easy, and we're getting into real difficult legal points. But the point of mentioning that is, even when things look catastrophic like that, it's not quite as black and white as people might think, and so they can still look to try and enforce matters. So coming back to the question, the chances of finding something that will get somebody off the debt are slim. Lenders have spent a lot of money getting very clever people to draft these documents.
Of course.
If all you needed to do was say this and get off them, they wouldn't be in business very long.
Even with the invention of ChatGPT?
Yes. We do get people that come to us with, done some AI search on general defences for guarantees, and most of the time they're just totally irrelevant. And that's, the internet's a wonderful thing, but you've got to be careful how you use it.
It's the application, isn't it?
It's the application. Yeah. Absolutely, it is. So if people are looking, people don't come to us in the hope that we can get them off guarantees, because it's very unlikely we can. I mean, we're not lawyers at the end of the day. So even if we found something significant, it would probably then have to go through the legal process to prove it. People come to us because they want a solution. And that solution might take into account any things that we can use to our advantage, if you like, in relation to the lenders not dotting the I's and crossing the T's, but we're providing a solution. And it's not just a solution for the guarantor, it's a solution for the lender as well. And remember, I can't force the guarantor and I can't force the lender to do it. What we can do is try and persuade the lender that it's in their interests to do what we're asking them to do, which gives a sensible way forward for the guarantor to move on.
And what are some other points that you would be looking at? What else are you going to be doing in these scenarios to help get to that solution?
Well, the other big thing is obviously the financial position of the directors. I don't know how many times people have come to me and said, oh, I've talked to somebody down the pub and he's managed to get 90% of his debt written off. And it's, yeah, but the circumstances...
We have lots of insolvency advisors in pubs up and down the country.
Yeah, absolutely.
Well, yeah.
Absolutely. It's amazing how many people of knowledge that you find after a few pints. But the fundamental point is everybody's case is different. There is no point in quoting averages or anything like that, because every case has looked at its own merits. Averages, by their very nature, some are going to be more, some are going to be less. And you've always got to go back to what I said before. You've got to understand the alternatives a lender has got to recover its money. And if you can't give them a justification, a reason, a business case, whatever it is, that says why they should take what we want them to do, and they've got an alternative that gets them quicker and more money back, they're never going to accept it. And so it goes back to, if you've got a house worth £1 million with no mortgage, you're very vulnerable. Whereas if you're in rented accommodation and you've got no assets, you've got more of the ability to be strong in your approach with a lender, but also you've still got the double-edged sword is that those people haven't got the ability to raise money to be able to sort things out, whereas somebody with a house might be able to raise some money. So it's a double-edged sword all the time, and you're fighting that. And
it always depends, doesn't it? It's really, you've got to get into the detail with them to give them a solution. But can you run us through some solutions that you've dealt with them, perhaps? Obviously.
There's two basic solutions that we can offer. On the one hand, we might look to try and say, well, the debt's £50,000. Perhaps we can get them to accept less as a walk-away position. But that requires the guarantor having access to a lump sum of cash within a short period of time, whether that be from family or from wherever. And the other alternative, if that's not feasible, then we might have to say, well, look, we'll accept, we're going to pay it back, but we have to pay it back in a way that's affordable to the guarantor. So much a month, those payments might be starting low and increasing further down the line, whatever it may look like. But ultimately, we've got to get that solution that gives the guarantor a way forward that they can afford. Especially, if you've got a director that's thinking about starting again in business, the first 6 months are quite critical. You don't want to be loading up very high payments on the new business from day one, because that's just going to cause potential issues for the new business. Maybe it may be possible in 6 or 12 months' time, but you've got to get through 6 or 12 months to be able to get there. So you've got to manage that process and try and keep payments low at the start, perhaps increasing further down the line.
Would you be able to give us some real-life cases without you explain sort of one where you got a big discount and another where you've managed to restructure it over a period of time? Could you just put it into like real context with some real life cases? Obviously, we don't need to know who the cases are, but could you run us through some real life jobs that you've worked on?
Yeah, it's always difficult without giving too much away, because for obvious reasons. But look, lenders will look at a proposition as long as it makes sense to them, whatever that proposition might look like. They might not agree to it, but as long as it makes sense, they'll at least consider it. So I think the best thing to sort of talk about is if we talk about what sort of scenarios would lead to a discount being obtained, because there's no obligation on a lenders to do any sort of discount at all. Well, those scenarios where maybe where the financial position of the guarantor is not fantastic, and so the options in terms of alternative recovery for a lender might be limited. A lender might take a view to say, you know what, given those circumstances, if we can come up with some money now, I'd rather take that than the risk of taking things over a more longer term. There might be some issues with the documentation that we've found that a lender might say, you know what, take your point, Gary, we don't want to really go down the route of proving that we're right, so let's try and do some sort of settlement. But what we've got to realise is that if we're going to do that, the money has to be available within a short period of time. They're not going to do a settlement and then give you 2 or 3 years to pay it, because that's you're having your cake and eating it, so to speak. So that's that sort of situation. The more traditional rescheduling of the debt scenario, the key factor there is understanding each lender's different, and each lender has their own ways of dealing with matters, and what might be appropriate for one lender might not be appropriate for another, depending on the circumstances. Some might be very generous, some might be
and
very...
you know this, don't you? Because these lenders you deal with do you have personal relationships with them?
The answer is yes, we do have personal relationship, but that's only to a limited
But
extent.
it helps, doesn't it?
It helps. Whichever way we look at it, whether we're dealing with a lender or a lender solicitor or whoever may be acting, we have a very good professional relationship whereby we can have a conversation, we can put things in writing, whatever we need to do to get things agreed. But ultimately, I can't force them to agree it, and I can't force the guarantor to agree it. I've got to create the environment whereby both can say, you know what, we can do that. And that's the ultimate secret. We're not bothered about proving who's right or who's wrong. All we're trying to do is to create that environment whereby both parties can say, that's something we can do.
2025, this is probably going to be going out April, May time. How do you see the next sort of 6 to 12 months in the UK panning out for directors of small businesses?
It's going to be another challenging period without a shadow of a doubt. Small businesses have come through a lot over the last 5 years. From if we go back to the financial crisis, that's going back quite some time. But from 2020, when we started with COVID, the implications of the final implications of Brexit, we've then had the war in Ukraine, the cost of living crisis, and now we've got increase on employers and things along those lines, all putting more and more strain on businesses. And businesses over this period have been hanging on a lot of business by the fingernails, and this may well be the final thing that tips them over the edge. So I see this year as being another difficult year for businesses, with insolvency levels not dropping off, but perhaps even going up. And at this moment in time, because we've got the uncertainty with America and Trump and the policies that they're adopting, it's difficult to see when things are going to get better. Things will get better without a shadow of a doubt, but it's difficult to see when at this moment in time. So that's my sort of understanding, and we're seeing that by the level of people that come to us for help. It is not getting any quieter.
What advice would you be giving a business owner out there today? General advice from your years of being in business. Things are getting a little bit tough. What should they be doing? What shouldn't they be doing?
Getting professional help is a key thing to understand where are you now and where are you going. Now, some people might be able to do that themselves, but if they can't, a little bit of money now invested with an accountant or whatever, getting these the financial information they need to properly understand where they are, where they're going, and what they need to get there is very important when things go tough. Because if today you find out you need £100,000 to get where you're going, and there's no way you can do it, you've found out today. Whereas the alternative is to borrow 10,000 tomorrow and another 10,000, and then ultimately not get there, and you've got yourself into more
£500,000 in debt.
And you got yourself in more difficulty. So the biggest thing I can say to people is really understand where your business is, where it's going, and understand the risks from it. And then you can make. There's no problem with directors making educated risk decisions, because that's what business is. The problem is where people make decisions without knowing the facts, and the reality is they're just guessing. They're making an educated guess rather than looking at it from a real risk perspective. So my biggest advice is making sure you understand where you are, you understand where you're going, and you understand what you need to get there.
Gary, it's been an absolute pleasure to have you on the podcast again.
Great to be here, mate, anytime.
What I like about you, and I say this to directors, is you're very, I believe you've always under-promised and over-delivered to people that we've introduced you to, and that goes a real long way. So if people want to find out more about you and what you do, it will be in the show notes, but where can they find you?
They can find us, our website is www.aftassist.com. They can give me a call on my mobile, which is 0776 416 7530. Always happy to have a chat. There's never any pressure from us about people wanting to come with. If people want to come to us with us, great. If we can have a chat with them and it's helped them out, fine. But we're here for people that need us when they need us, and that's the key factor. And the other thing, I know it's the last thing to say, but the way we work, most of our fees are only payable if we succeed. So we don't charge lots of money up front. We do charge a little bit up front, but most of it is only payable if we actually provide a solution that the guarantor can afford and the lender can live with. And
so that's very little risk.
There's very little risk, yeah. And that's the way I think this should be done. It means that we don't take people on
unless we've got a good idea that you're going to get something, and that's not the norm, because there are other people that will charge like wounded rhinos up front and not deliver.
There are, and people have to be careful because they're in a very vulnerable position, and people, do grasp onto things thinking it's a life belt sometimes, and it's probably a brick.
Gary, you're an absolute gent. Thank you, pal. Appreciate it.
Cheers.
Bye-bye.
See you later.
Chris Worden, that was another episode of the Director First podcast. If you are struggling with business debts, you are failing on time to pays, getting behind with C-bills, RLSs and bounce back loans, take advice today. We are free, independent and impartial. If you have any questions, drop them in the comment section below and I will respond to them personally. Hit like, hit subscribe. Thanks for your time and see you soon. Goodbye.